How to take a Ccma arbitration award on review to the Labour Court. Hi, my name is Aslam Moolla and I am a registered attorney. The first important point to understand is that a review application at the Labour Court is initiated by a document that is called a notice of motion. And attached to this notice of motion is a document called a founding affidavit. The person who is applying to the Labour Court to have a Ccma award reviewed is called the applicant. The person who responds, which is usually the other party to the Ccma case, that person is called the respondent. The applicant must complete the notice of motion and the founding affidavit. The founding affidavit must set out the grounds on which the applicant is relying on to have the award reviewed successfully at the Labour Court. For more information about the grounds, you're more than welcome to have a look at a video that we've done separately on the grounds for review at the Labour Court. Now, it's very important to understand that any kind of review proceedings from the Ccma or bargaining council must be initiated within 6 weeks of the applicant receiving the award or the ruling from the Ccma or bargaining council. In other words, you have 6 weeks to make your application to the Labour Court. If you're out of the 6-week period, the Labour Court can condone your late review application. In other words, they can accept your delay provided that you show good cause on why you have submitted your application late. And remember, the other side has a right to oppose your review application and your late filing if you are late. The next important step is that a case number must be obtained from the registrar of the Labour Court in the relevant area that you are applying in, prior to you filing your notice of motion and founding affidavit. You do this by phoning that particular Labour Court. After you got the case number and your notice of motion and founding affidavit is done, then the review application must be served on all of the respondents, which is either the other employee or the employer, whatever is applicable in your case, as well as the relevant Ccma or bargaining council. Now, proof of service must be done and filed at the Labour Court as well, together with your notice of motion and your founding affidavit. There are some interim procedures that also need to be done. For example, the filing of the record of proceedings from the Ccma. The decision is then made by the Labour Court, and from there, that decision can also be taken further to the Labour Appeal Court if necessary. Now, it's also very important to understand that the enforcement of the Ccma award is halted or it's stopped pending the outcome of the Labour Court's decision. It's also further important to note that security must be filed if an employer is taking a decision on review. In other words, if the employer is taking, the company is taking the case to the Labour Court, they must file money, what we call security. 24 months if the employee is reinstated, or 12 months of the employee's salary if compensation is awarded at the Ccma. If the employee is taking the case to the Labour Court, no such security needs to be filed. In summary, the process of a review application can be quite a complex one, as you've seen. It is highly recommended that the applicant, which is the person who's initiating the proceedings, either gets the assistance of a labour law attorney or speaks to a labour law attorney who can advise them on the rules and procedure relevant to their particular case. The reason why is the Labour Court is more strict on the rules and procedure compared to the Ccma. If you need help in your situation, whether that's preparing for a disciplinary inquiry or a Ccma case or a Labour Court matter, you're welcome to click the link below and book an appointment with our office. I wish you all the best and I'll speak to you soon.